Roten.
Say again, I couldn't hear you.
Jonathan Roten.
Jonathan R. Roten, yes. Jonathan Richard.
Roten, 64A District Court here today. I'm going to arraign you on felony charges.
Roten 452-04.
Please listen, okay? I'm going to go over some things. Okay. You need to listen because it's important that you hear what I have to say. I'm first going to advise you of the rights. You do have the right to remain silent. Anything that you say orally or in writing can be used against you in court. You have the right to the assistance of an attorney and to have an attorney present during any questioning consented to. If you cannot afford to hire an attorney, you have the right to an attorney appointed at public expense. And you have a right to be represented by an attorney at all subsequent court proceedings. As a matter of fact, we do have an attorney in the courtroom here today. It's Ms. Vandenberg from the Public Defender's Office. She's a defense attorney, and she's available should you have any questions at any time. And finally, you have a right to be considered for pretrial release or bond. Do you understand those rights, Mr. Roten?
Sir, yes, sir.
Very well. Your charges are in file number 211110FY, State of Michigan versus Jonathan, Jonathan, middle of Richard, common spelling, last of Roten, WROTEN. Mr. Roten, the file alleges that on or about October 31st, yesterday's date, in Easton Township of Ionia County, that you committed the following offenses. Count number 1, assault with intent to murder, that you did make an assault upon Ted Rux with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony offense, punishable by up to life in prison or any term of years. Count 2 alleges same date, same location, that you committed the offense of assault with a dangerous weapon. That you did make an assault upon Jessica Bowman with a dangerous weapon, to wit a sword, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. This is also a felony, punishable by up to 4 years prison and or a $2,000 fine. You understand those two charges, Mr. Roten?
Yes, sir.
Okay, there are several additional charges. Count 3 alleges same date, same location, that you committed the offense of armed robbery, that you did in the course of committing a larceny of money and cigarettes, use force or violence against a person present, to wit T. Rux, and in the course of that conduct possessed a sword, a dangerous weapon, contrary to MCL 750.529. This is again a felony, punishable by up to life in prison or any term of years. Do you understand that charge as well?
Yeah.
Okay, then there are 4 additional counts of resisting and obstructing a police officer. I'll read through them. We'll start with count 4. It alleges same date, same location, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Austin Granger, a sheriff or deputy sheriff of the county of Ionia, that you, the defendant, knew or had reason to know was performing his duties, contrary to MCL 750.81D. This is a felony offense, punishable by up to 2 years prison and or a $2,000 fine. You understand that charge?
Yeah, I plead not guilty by reason of entrapment.
We'll get to that. Just let me finish reading the charges. Count 5 alleges same date, same location, that you committed a second count of resisting and obstructing a police officer, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Sergeant Stroud, a sheriff or deputy sheriff of the county of Ionia, that you, the defendant, knew or had reason to know was performing his duties, contrary to MCL 750.81D. Again, a felony offense, punishable by up to 2 years prison and or a $2,000 fine. Count 6 is a third count of resisting and obstructing a police officer. It reads identical to counts 4 and 5.
I put charges on cops, and that's why they put these charges on.
Please don't interrupt. All right. Count 6 is a third count of resisting and obstructing a police officer. It reads identical to counts 4 and 5. Just simply involves a different officer, that being Deputy Granger of the Sheriff's Department. And it carries the same maximum possible penalty. And finally, count 7 alleges same date, same location, that you committed a 4th count of resisting and obstructing a police officer. Reads identical to counts 4 through 6, simply involves a different officer, that being Officer Jones of the Ionia.
I want to file charges of assault and entrapment. They assaulted me.
All right,
Not cop.
Mr. Grover, you're going to continue to interrupt me. We will discontinue this arraignment today. You'll sit in jail another night without bond, understood?
No, sorry. I'm sorry.
All right, thank you. And finally, there is a habitual offender fourth offense notice on the complaint as well. Refers to 3 prior felony convictions or attempted felony convictions, one of which was on October 10th of 2012 for the offense of violation of the Controlled Substances Act. That was out of the 17th Circuit Court for Kent County, state of Michigan.
What are you talking
The
about?
second on September 17th of 2014 for another violation of the Controlled Substances Act, also out of the 17th Circuit Court. And the third was also on September 17th of 2014 for another violation of the Controlled Substances Act, also out of the 17th Circuit Court. Therefore, you, the defendant, is subject to the penalties provided by MCL 769.12, penalty being life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years, and the maximum penalty cannot be less than the maximum term for a first conviction. You understand? So essentially what that habitual offender notice means, Mr. Roten, is that it actually changes the maximum possible penalty on those counts 2 through 7 to the potential of 15 years in prison rather than 4 years in prison on counts 2 and counts 4 through 7 was 2 years. That becomes 15 years as well. Do you understand that?
Sir, yes, sir.
Okay. All right. I heard you mention pleading not guilty. The court will enter a not guilty plea, and I'm going to schedule you for a couple of court appearances, the first of which is Monday, November 15th at 1 o'clock in the afternoon. I'm scheduling you for what's called a probable cause conference. It's a meeting with the prosecuting official. Do you have plans to retain an attorney to represent you on these charges?
If I've got a bond, I'm going to spend all my money on getting a bond and a tether so that I can take care of my animals. I have priceless animals that are not being taken care of, and I need to get out there till I can get a family member to come up and stay here. They all live in Tennessee, and people have been attacking me. I feel like I've been at war. I called every agency to help me. I'm willing to give up my house to stay. You can put me on. I can't hear you.
I'm going to explore the option of a court-appointed attorney with you, okay? So I'm going to ask you a few questions. It is important that you be completely truthful and accurate, all right?
Yes, sir.
So, are you currently
I'll do my
employed?
best.
Are you currently employed?
No, not really. My mom helps me out with the chickens. So I take care of chickens and raise chickens because she likes chickens. I send her pictures of those, but I get SSI.
Do you have any source of monthly income?
I've been trying to not need SSI. Huh?
Do you have any source of monthly income right now?
I have chicken eggs. I'm a medical marijuana grower, and they've been attacking that. I'm having trouble keeping my farm because I've been beefing with the local dispensaries and the people that grow chicken. They've been attacking me.
Do you have any money in savings?
I should have a savings account. My mom knows about it. I think. I don't know. I don't know if I do. Like I think someone's trying to take it. Huh?
Okay, just listen to me. Answer my questions. My questions only. Do you know how much money is in your savings account?
No, I have no idea.
Based on what you're telling me,
My sister told me I don't have it.
Attorney, please listen. I am appointing the public defender's office to represent you. Ms. Vandenberg will speak with you shortly. Again, a not guilty plea has been entered on all charges. I'm scheduling you for those two. As I mentioned, your first one on Monday, November 15th at 1 o'clock. So what's going to happen on that day is your attorney will meet with the prosecuting official on your behalf and meet with the prosecuting official, discuss the charges. Your attorney will keep you informed as to what the conversation is. They'll also make arrangements to have you available to, whether it be by Zoom, in person, or whatever. So stay in touch with your attorney. Following that, you're then scheduled for what's called a preliminary examination on the following Monday, November 22nd at 1 o'clock in the afternoon. That's an actual hearing in our district court courtroom. It's a hearing where the prosecuting official has to show that there's probable cause to believe that a crime was committed, and that you're the one that committed the crime. It's somewhat like a little mini trial, so to speak, where they can call witnesses and so forth. I'll have a copy of this form delivered to the jail. That'll go on your property. That'll serve as your reminder for those appearances. It has those dates and times on it. It is important that you make those appearances. A failure to do so would result in the court issuing a bench warrant for your arrest for contempt of court. Understood?
Sir, yes, sir.
Let's discuss your bond. Where do you reside right now?
1988 Stanbro Road. There's two, it's kind of weird. There's two properties kind of combined one, but my address, my primary address is
How long have you lived there?
for about, a little over 2 years now, isn't it?
We discussed your, and that's kind of questionable right now. I guess Mr. Lobus from the prosecuting attorney's office is present. Mr. Lobus, would you like to comment on bond?
Yes, Your Honor, thank you very much. MCR 6.106 B1B allows the court to deny pretrial release to a defendant charged with armed robbery if the court finds the proof of defendant's guilt is evident or the presumption.
They were trying to hurt my, they killed my birthday.
Evidence that the defendant is not likely to present danger of persons. In this case,
Mr. Roden, please do not talk while Mr. Lobus is talking.
In this case, Mr. Roden entered a store with a katana. He viciously slashed at the clerk's head and cut his face rather severely. This is all captured on video, by the way, it's very clear. He then forced the clerk to the cash register, whereupon he took money and cigarettes. Upon leaving the store, threatened another individual with the same sword. Although he didn't injure her, but he did threaten her, place her in fear for her life. Mr. Roden also has a long, extensive criminal history. Began in 2003 with an attempt, felony criminal sexual conduct, and continued on into 2010 with possession of controlled substance. Another 2010 disturbing the peace. 2012 he failed to register as a sex offender. The two other felonies in 2012 have already been mentioned in people's habitual fourth supplement. Also in 2012, there was an attempt, misdemeanor, resisting obstructing. We had two additional felony controlled substance convictions in 2014. There was an additional one in 2018. Additional two convictions in 2018. There's an assault and battery in 2019. Clearly, there is significant evidence that Mr. Roden is guilty of at least the armed robbery and the assault and attempt to murder in this case. And it is evident that he also presents a danger to other people. So we ask the court to deny pretrial release.
Ms. Vandenberg, any comments on bond?
I would ask for a cash or surety bond.
All right, Mr. Roden, these are very serious charges. And what makes them even more serious is the fact that you have the habitual offender fourth offense notice as well. It just compounds the potential for prison time.
I believe that's an act.
Referred to your prior criminal history. There was some assault type history there. There was some drug crimes. There was an attempted criminal sexual conduct charge, a possession of meth charge in 18 as well. It's also, you also referred to the probability of conviction in this case was quite high, given the fact that there was video of the incident at the location of the incident and the fact that you were in possession of, I don't think Mr. Lobus referred to it, but it was brought to the court's attention that you were still in the possession of the sword at the time of your apprehension. It's something you commonly carry around. So I would agree with Mr. Lobus in this case. The potential for conviction is quite high. You have a lengthy criminal history. There was a serious assault here, and certainly I'm not about to put others at risk with you being out and about. So I'm going to honor Mr. Lobus's request for.
Can I be on?
There will be no bond. I do have what taken into consideration also was the fact that I have another felony complaint to arraign you on as well. So there's no bond in this case. However, there are some conditions that I'm going to go over with you. I need you to listen carefully. First of all, you need to personally appear for all of your court appearances. You must abide by any judgment entered in this case. You must not leave the state of Michigan without permission of it. You must not commit any crime while released, and that means you have to be on your very best behavior while at the jail as well. You must immediately notify the court in writing of any change of address or telephone number. You must not use alcohol, marijuana, or any illegal controlled substance. You must not possess or purchase a firearm or other dangerous weapon. You must not assault, harass, intimidate, beat, wound, or threaten Ted Rux Jr. or Jessica Bowen and their immediate families. And along with that, you are to not have any direct or indirect contact with Ted Rux Jr., Jessica Bowen, and their immediate families. Immediate family would consist of parents, children, and siblings. So not only can you not speak to them face to face, nor can you call them, text them, email them, Facebook them. You can't even ask a third party to tell them anything. And that includes from the Ionia County Jail, so you cannot call them from the jail. Finally, you must not go to their residence or their place of employment. Information about this order is going to be entered into a computer system that all police officers have access to. And in the event any officer determines that you violated any part of this order, you could be jailed immediately if at one point you are released. And if found guilty of that violation, you could be jailed for up to 93 days just on the violation itself, and yet still have the original charges to deal with. So it is essential you follow every aspect of this order. It is in effect immediately as of right now, and it stays in effect for 1 year from today's date. So it's in effect until November 1st of 2022. I'll provide you with a copy of that order. Do you have any questions regarding that order?
I'm completely confused and I don't understand any of this, but I don't have any questions.
Okay.
I'm
Well, I
so
want to make sure, right? I'm going to arraign you on another complaint now. It's file number 211109FY, State of Michigan.
What did I do?
This file alleges that on or about October 20th of 2021 in Easton Township of Ionia County, that you committed the offense of resisting and obstructing a police officer, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Deputy Granger, a sheriff or deputy sheriff of the county of Ionia, that you, the defendant, knew or had reason to know was performing his duties contrary to MCL 750.81.
assaulted me with a knife.
This is a felony offense punishable by up to 2 years prison and or a $2,000 fine. The complaint carries another count of resisting and obstructing a police officer. It's listed as count 2. It reads identical to count number 1, just simply involves a different officer, that being Deputy Richards of the Sheriff's Department, and it carries the same maximum possible penalty. So there are 2 counts of resisting and obstructing a police officer alleged to have occurred on October 20th. You understand that, Mr. Roden?
Sure. Yes, sir.
Okay, this is the price that I read to you.
I don't really understand though. I don't understand.
The Public Defender's Office to represent you on these charges as well, and I'm scheduling you for the very same dates on this file that I scheduled you for on the previous file. So they'll hear both cases together. For the record, this file does also include a habitual offender notice, 4th offense notice. It refers to actually 4 prior felony convictions, one on July 29 of 2003 for the offense of attempted criminal sexual conduct, 3. That was out of the 17th Circuit Court for Kent County. The second on October 10, 2012, violation of the Controlled Substances Act, also out of the 17th Circuit Court. And then 2 convictions from September 17th of 2014, 2 more convictions of violation of the Controlled Substances Act. Therefore, you, the defendant, is subject to the penalties provided by MCL 769.12, the penalty being life if the primary offense has a penalty of 5 years or more, 15 years or less if the primary offense has a penalty under 5 years. And in this case, the primary penalty on these 2 charges is 2 years. So what that means is rather than, because of these prior convictions, those penalties become the potential for 15 years in prison. Do you understand that, Mr. Roden?
I think so. Yeah. Yeah. I'm just going to say I do. So I can get. I'm just going to say that.
Questions of either myself or Ms. Vandenberg from the Public Defender's Office?
What?
you have any questions either of myself or Ms. Vandenberg from the Public Defender's Office?
I have a statement. I called police officers. I called everyone. I said that people were trying to do stuff to me and they didn't get me. They coerced me.
Your attorney is not gonna want you making comments right now, okay?
Yeah, don't make any statements right now, okay? An attorney from my office will set up a meeting with you over the video system through the jail and we'll talk about all of that.
Thank you.
You're welcome.
All right, you're all set, thank you.
Sorry.
Yes. Officer, when you bring the next inmate, hold off on Wilkins and Castile because I'm still waiting on their paperwork, so we can do either Camp, LaRoche.
Your Honor, we need to deal with bond on the R&O.
Oh, yes, thank you. Yes, your bond on the R&O charge is $10,000 cash or surety.
Okay. All right.
211109FY. That included the 2 counts of resisting and obstructing. Bond is $10,000 cash or surety. Thank you, Mr. Rose.
The rest, sir.
Okay. Thank you.
Did you say I could bond out or not? Turn the speaker back on.
We're gonna head back up to booking.
Did you say I could bond out? I didn't understand you.
You have no bond. No, you cannot bond out on the,
You said it was a $10,000 bond.
no bond out on the file, including the armed robbery charges. You do have a cash or surety bond on the other file regarding the resisting and obstructing charges, but no bond on the armed robbery file. So no, you may not bond out.